Is that better? Okay. We'll start over and say good afternoon. It's really nice to see such a great turnout for this forum that we're having. We have guests with us today, which is Jennifer Jacobson, which is the Attorney General Counsel for Hidden Valley Lake Association. We also have Williams plus Patton that's going to be doing a presentation. To keep our time frame down and get as much information to you as possible, we do have index cards that's going to be at the back. If you have questions after Jennifer has done her presentation, we're going to ask that you write those questions down for us. The reason to handle it in that manner is we will take a 5-minute break, go through those index cards, and see if we had repeated questions, and those are the questions that we'll respond to. If we can't get back to the questions today that you have put on the postcard, then moving forward, we will respond back to you. So that will help us with a timing issue, making sure that we have addressed everyone's concerns. So again, thank you for coming. And I'm gonna turn this over to Bill Waite, who's gonna go over a couple items with you, and then we will move forward with Jennifer. Again, thanks for coming.
Thank you, everybody. I appreciate it. Can everybody hear me? I just wanted to go over a couple of things like I did at the last workshop. This is meant to be informative. It's meant to give information out to everybody here. And so whoever has the floor, what do they call it? Rules of decorum are going to apply. Whoever has a floor has a floor. Anybody that wants to speak over or talk while that other person is talking is basically writing their ticket to be asked to be excused and leave. If you decide that you do not want to even do that, we do have security here that will escort you out, and if that has to get to that point, then we will just recess everything. One way or the other, the intent is we're going to be out of here at 5 o'clock, and I would like to get through as much information as possible, and I would like everybody to be able to come away from the meeting actually being informed. And I think you'll see by the way we have the program set up and everything, most all the questions that have been raised, in fact all of them I think we've gone through pretty good, mostly all of them anyway, will be answered one way or the other by our speakers here today, or hopefully if not, then in the question and answer session we'll get done. We're going to basically allot an hour and a half maximum per presentation. Jennifer will speak and open up to a couple of questions which I think have been pre-set out for her, and then we'll do a little adjournment like Cindy was saying, and go over some of your questions and then try to answer those as well. They will then, at the end of an hour and a half, then we will go on to the presentation from Williams plus Patton. So we'll do the same format. They'll do a presentation, write down your questions, anything, we'll go through those questions and then answer them after the fact. And one way or the other, my intent is to get out of here by 5 o'clock, give or take a minute or two. So please honor the rules of decorum in conducting yourselves here today. So with that, who's going to start this? Jennifer?
I will be happy to start. Can you hear me? Hi. Hi, I'm Jennifer Jacobson with the Law Office of Bidellen and Jacobson. If you see the name Bidellen, you're going to probably pronounce it Beta-line like everybody else does, but it's Bidellen and Jacobson. We're attorneys that work in Northern California exclusively with homeowners associations. I've been working in this area of law for over 20 years, and we represent over 1,000 community associations in Northern California and Northern Nevada. So we work with community associations such as yours every single day at our office. And I have been to a lot of these meetings. I know there's a lot of questions that everybody has today, and I appreciate everybody coming on a Saturday, first of all. I know this is your time off. And so coming to educate yourself is always a good thing as a member of the community. The board would like to hear your questions. They've asked you to write them down on comment cards so that we can try to answer the majority of questions first that are coming to the forefront based upon what the concerns that you folks have today. I kind of wish the architect could go before me so I could kind of hear a little bit more about the project, because I know I'm not as well educated or as well versed about the project as some of you may be or will be later on today. So the board just asked me to give you a general overview of a community association. How many people here have lived in a community association before coming to Hidden Valley? How many of those people have served on a board? Okay, so we have a pretty good representation of board members. So you guys know how challenging it is to be on the board of directors. The community association is a private, nonprofit, mutual benefit corporation. It's designed for no other purpose other than the benefit of you folks. Your corporation serves no purpose outside of Hidden Valley. What I mean by that is you're not a charitable corporation, such as we think of the Susan B. Komen Foundation, fundraising for charitable purposes. Or we think of a public benefit corporation like wetlands. There's a wildlands that runs wetlands in Northern California. And developers have to buy blocks of wetlands to set aside if they're going to be consuming wetlands when they build a project. So those would be examples of different types of nonprofits that are not a mutual benefit corporation. Your corporation serves one purpose and one purpose only. That's to run this community. And the individuals who run this community are your board of directors. The individuals sitting up in front of you have been elected by the membership to serve your community. So under the Corporations Code and the Davis-Sterling Common Interest Development Act, the board of directors is charged by majority vote of making all of the day-to-day decisions for your corporation. There are times when the members are entitled to vote, and the vote is not allowed to be taken by the board. Probably the most classic example of that would be the election of directors. The Civil Code calls for the directors to be elected by the members. So they are your constituents that serve your community. So that would be one example. Another example would be a recall. And everybody here today knows that there's a recall petition. It's been mailed out. Okay. That would be another circumstance in which the Corporation Code calls for your community to vote. And that has been sent out to the membership. The vote will be taken. The inspector of elections, similar when there's an election of directors, will sit down and count those votes, validate them, and make a determination as to whether or not the recall has been successful. So, Bill, do you have a couple questions that you want to ask me? Because I kind of feel like I'm just free-flowing, and I know you have some questions that you want to ask me that might help me hone in on some of the questions that you've been seeing coming from the community.
One of the big questions is paragraph 2 of our bylaws, where it talks about the powers of the board of directors. Can you kind of go through those for us?
Sure. So 2.02 of your bylaws talks about what the board is able to do, and it has a very long list of items that are reserved to the board, their corporate powers to exercise on your behalf as the members. Now that is counterbalanced by other provisions in the law and 11.05, and I think 11.05 is maybe the focal point of what a lot of the questions are that you have today. 11.05 talks about the members having a right to vote on certain items. Now, just so you know the history of that section, it comes out of the DRE regulations, the Department of Real Estate, which is now called the Bureau of Real Estate, the BRE regulations, and the developers are required to put that in your documents so that the developer, when they're building the community, cannot utilize a lot of the association's assets for the developer's benefit. You could imagine if they took the members' assessment stream, set that up to build common facilities for the community, and then they were able to sell homes in that community, they could benefit by that, by tying your future assessment streams to a project that you might not be in favor of. So that's where that provision comes from. Now, it's not designed to address every single decision that your board makes. I think that there's some confusion, isn't there, Bill, about what sort of circumstances the 11.05 vote is required to address. Well, some of those circumstances would be when the board is trying to acquire a new project, maybe annexing in a, you gave an example earlier, didn't you, to me, of
perhaps annexing land that abuts ours over on Coyote Road, for example.
So a big annexation like that, where you were acquiring property for the community and annexing it into the association, that may trigger approval under that section. So it's not intended to address circumstances that we're talking about today, which is refurbishment under the law of your common areas. And why I say under the law is I think the architect, again, I wish I was speaking after you rather than before you, we'll talk a little bit about some of the ADA requirements that we need to come up to, right? Are you going to address that? Or maybe not? Yeah, okay. So that's probably the biggest thing for you folks is bringing your community and bringing your common facilities into compliance with current building codes and requirements. You're going to see some changes because there's been some significant changes in the accessibility laws that have come into focus since these facilities were first built. So that would be one example. Are there any other questions that you have?
I think relating it to our project here, for example, and you talked about this one other time in one of our other meetings, that what the bank requirement would be, should the association apply for a loan to build the project. Can you go into that a little bit as well, what they're going to require from you?
Sure. So if the association engages in a project, they may go apply for a bank loan if they don't have enough money set aside either in the operating or reserve accounts for a project. And so if they go to the bank and request a loan that will be made on behalf of the association, they will not be encumbering the common areas with any sort of mortgage for purposes of securing that loan. That is because under the Revenue and Tax Code, your common areas actually have a zero tax basis. I don't know if you guys know that. The price of the common facilities is built into the prices of your homes. Because once you buy the home here, you buy it with all of the amenities that come with it in the common facilities. So the common facilities by themselves have a zero tax basis. They don't have an independent tax basis on their own. So it cannot be pledged for an encumbrance by a bank. So what the association would be looking at is using the future assessment stream to secure the loan. And so what the bank will require is to have a legal opinion written by your corporate counsel for your community association to them, telling them what requirements are in place under your governing documents in order for you to take out a loan. Then they will have their own independent attorneys review that opinion and make a determination as to whether or not they'll accept that opinion or they require further clarification.
Thank you. That clarifies that, and a couple of the questions that are on my list I think you've kind of gone over. One of the things that certain members have brought up is this question: does Davis Sterling address a vote on projects such as replacement and/or major repairs of facilities?
It doesn't address that specific question. It doesn't talk specifically about capital improvements, which is the term that I would like to utilize for a new project, because that's a term of art under the VRE regulations. The Davis-Sterling Act does not address that independently. However, there are requirements in the Davis-Sterling Act that may trigger a member approval. For example, if the board is to raise regular assessments more than 20% in any fiscal year, that requires a vote of the membership to go above that 20% threshold. Similarly, if they adopt special assessments, which in the aggregate exceed 5% of your budgeted gross expenses for a fiscal year in one fiscal year, that special assessment would require a membership approval. But independent of those types of requirements, no, there would be no independent requirement of the Davis-Sterling Act.
All right, thank you. That answers that question. Susan will get to our questions after I get through this list. The next question on our pre-prepared questions is under Corporations Code 5033. Does that Corporations Code actually state that we have to have a vote?
So 5033 and
for this project, that
okay,
is.
5033 and 5032 of the Corporations Code are actually definitional sections. Those define terms of art that are utilized in the Corporations Code. 5032 talks about a vote of the directors, and 5033 talks about a vote of the membership. And what is a majority vote? How does the board take an action? So 5032 says that the board takes action by majority vote. None of the individuals here can independently act outside of the board. They must act within the board context under majority vote. Similarly, with respect to the members, if the members are to take a vote, if it's required by the Corporations Code or Davis-Sterling Act or your governing documents, that addresses what a majority vote of the members would be under those circumstances.
Thank
but
you.
it's simply for definition. It's not for purposes of giving a definite program for a vote.
Right, thank you. Getting away from the voting thing and the Hartman project a little bit, another question on this list that has come up frequently is a question that came out regarding a letter that we wrote to Mr. Greenberg back when. And is that this could be brought up. Is this an attorney-client privilege, or is this something that can be discussed in open session?
My client is the corporation, and I speak to my client through the board of directors. My client is not the general membership, so unless the board were to give me the permission to waive the attorney-client privilege, the board holds the privilege, I do not hold the privilege. And the board has not authorized me to share the contents of that opinion with the entire membership, so therefore I cannot address that question.
Thank you. So, and the last question on this list, and then I'll get to questions that the board of directors here might have. There may be questions about the recall and corporations code 7224 and our bylaws section 707 on filling vacancies. Can you kind of go over that topic a little bit?
Sure. So there's a program in place under your bylaws for the recall to be successful. It requires a quorum of the membership appear in the voting process. So if you don't have a quorum, the vote, like any other vote, would not succeed for lack of quorum. And then once the quorum is established, if it is in fact established, then it would require a majority vote of those members who are casting the ballots in the election. If those two requirements are independently met, both requirements, then the recall would be successful. And the question becomes, who appoints the person to come into the seat that has been recalled? And your bylaws call for the board of directors to make that determination by majority vote. So they would make that determination. If the board were to fail to make that determination, then the members would have the right to vote that person in. So that's the protocol called for under your bylaws.
Thank you. That seems to make it through the questions that I have been prepared for me. Susan, I'll start with you down here.
I wanted to ask you to address the issue of, or define fiduciary duty, as well as define the board of directors' roles, responsibilities, kind of in general, and what our personal liability is, and how we are protected from personal liability under certain circumstances.
Yeah, so for those of you in the audience who've served on boards of directors, you've probably gone through some board training with the folks that you guys worked with in the past, so you're familiar with this concept. As I said, the board acts as a majority. They can only vote as a majority. No individual, unless they're specifically delegated board authority, can have that authority independent of the board. So once the board makes a decision by majority vote, the law protects that decision from being overruled by a court of law as long as it's made in accordance with the business judgment rule. The business judgment rule says as long as the board members are acting as fiduciaries, which means they're putting your personal interests as the membership ahead of their own interests as individuals, is the highest level of trust that's placed in any individual under the law. A trustee, a fiduciary, is a very high standard. So this board must exercise its decision-making authority in accordance with its fiduciary standards to you as the membership. And the courts will not interfere with the decisions made by your board of directors unless they don't follow the law, they don't follow your governing documents, or they believe that the board has acted arbitrarily or capriciously, which is a very high standard to meet. So basically, unless the board were to ignore the law or ignore the requirements of your governing documents, its decisions will be upheld by a court of law under the business judgment rule. And there's a line of cases, Lambden and Narstadt, Dolan King, that all under California published appellate decisions reaffirm that requirement over and over again. So the board does have the obligation under the law to put your interests ahead of their own personal interests. As stated, the board can sometimes be individually liable. And when we're doing board training, this is when everybody kind of wakes up in the middle of the board training because they want to go, oh, whoa, when am I going to be individually liable? Because I'm a volunteer. I don't get paid to do this. I'm not getting paid to be here on a Saturday, Bill says. So how can I be individually liable? Why is my house on the line here? Well, board members, if they step outside of the scope of their fiduciary responsibilities and act willfully, wantonly, or grossly negligent, they can be held personally liable for their actions. My favorite example, and I'm sorry you guys, you've heard this one already in training, but my favorite example was a Saturday meeting, kind of similar to this. The vice president of the board was getting in a little bit of a heated discussion with one of the members at a board meeting. Actually, it was the annual membership meeting, I take it back, not a board meeting. And the individual apparently was a little out of order, and the vice president was a little out of order, and it erupted into a fist fight between the two of them. So the vice president was a very fit young CHP officer, and the member was not. So when I got that call that Saturday as the ambulance was leaving the annual meeting, very fit, apparently very fit. So as I got the call, I said to the manager, don't worry about it. And he said, well, why shouldn't I worry about it? I have an ambulance and all these people. It doesn't matter. We're not going to be responsible as the association. He clearly acted outside of the scope of his duties, his individual duties. You cannot beat up members at meetings, just so you guys know. That is not part of your duties. So that's a classic example, and that board member was personally responsible for that personal injury lawsuit. That did go on his homeowner's insurance. So that would be an example of somebody being personally liable. Did I get to all your questions, or did I just? I'm sorry, I tend to talk a lot, so I don't know if I answered your question or not. Was there?
Okay. Bob, do you have a question?
Yes, thanks, Jennifer. Some members have suggested that even though we're not required by Davis Sterling or by our bylaws to hold a vote, that we should have one anyway. What are the pros and cons of that concept?
Well, you know, it's interesting. When I came in today, I saw somebody handed me a survey that you guys do. It sounds like you kind of regularly do surveys out here, which I think is a good thing.
No, we don't.
You don't? Okay. Okay. Well, I thought I saw a survey about a restaurant thing. Wasn't that?
Just did.
Okay. So you just did one. So doing it once is doing it regularly. So you have done it once. So doing those types of I call them straw poll votes, canvassing. It's a helpful tool for the board to get input from the membership. Holding meetings like this is a helpful tool for the board to get input from the membership, because remember, they're supposed to be acting on your best interests. So in order to make the decisions, sometimes, especially when they're really hot potato decisions that the board doesn't know which hand the hot potato should be in, and they can't among themselves really decide which direction they should take, they might go to you, the community, and ask you for that input. And I think that's kind of what we're doing here today, is trying to get some education out there about the project and about what the board is doing, and to also get some valuable input from you as the members about what direction you would like the project to take. So, did that answer your question? Okay.
Good. Thank you. Bill, do you have a question? Herb?
Yeah, thank you for coming, Jennifer.
You're welcome, Herb.
Yeah, I'd like to read an opinion from the law firm of Davis Sterling, and I'd like your
It's not a law firm, just so you know. I've told you this.
That's right.
It's not a law firm, Herb.
They're an
If anybody,
organization.
has anybody seen davissterling.com? Okay, davissterling.com is a law firm. It's not the state legislature.
Right.
It's very misconstrued
I
that.
said law firm.
But they have a different name. I was just going to say, because they're not the law firm of Davis Sterling. Yeah,
Adams.
because it sounds like the law firm is the actual legislature,
Yeah,
which
no,
is
no, I didn't
confusing.
mean that.
So, yeah.
I know the difference.
Okay, good.
Yeah,
So
no,
this is an independent opinion of an attorney who has put this on the internet, and so you can
Exactly
pull the
right.
opinion down.
That's
Yeah.
exactly right.
Just so you know where it's coming from.
So I'd like your opinion, please, on this, if
Okay.
you wouldn't mind. So I'll just read it to you. It says it's concerning significant upgrades. Boards should take advantage of improved building materials and designs whenever possible. However, discretionary upgrades that are appreciably more expensive need membership approval. For example, replacing a chain link fence costing $25,000 with slump stone costing $100,000 requires membership approval. And then they go on and on. So I'd like your comments, your opinion, please, on the comment that discretionary upgrades that are appreciably more expensive need membership approval. What's your take on that?
Does he cite, because I don't have that sitting in front of me, but does he cite what provision he's looking at in support of that opinion, or does he just state it just the way you stated it?
Just an
That's
opinion,
not the
and
truth.
I'd like yours.
Did he cite, I'm just wondering, is he looking under a bylaws or something somewhere?
No,
Okay. Oh, you want me to read that small print?
no, it's just an opinion, and I'd like your opinion.
Yeah, so case law that addresses capital improvement. So these cases that are cited on the bottom of this opinion are, he's saying generally under these cases, this is the opinion that he believes those cases to espouse.
Right.
And I would just tell you that that would be drawn from a different provision in a bylaws that would be, it's different than yours.
Okay.
And the actual DRE regulation or BRE regulation, I keep getting it confused because it's just changed this year, Bureau of Real Estate regulation that those cases are founded upon is not exactly what your bylaws say. So your bylaws do not use the 5% capital improvement language that's used in the actual regulations. So I think that that would be a different opinion than the opinion that he might give based upon your bylaws under 1105, because your bylaws are a little bit different.
Okay.
So that's why, and you know, unfortunately he states that, you know, we as attorneys, just so you know, we Monday morning quarterback each other all the time. So we're always in my office, always debating whether or not they give the right opinion on this website. We ourselves are, it kind of scares us as attorneys to give opinions in a vacuum like this, because he hasn't read your bylaws, but you're reading that as being the law.
No, I'm just asking for your opinion.
Right, no, but I'm just saying you as the consumer are reading that as being the law, when in actuality he doesn't put enough disclaimers in there to explain what he's really opining on. So because they're short, kind of pithy kind of opinions, they don't always give you the full appreciation of how that opinion may apply to your facts.
And could you comment on one other opinion, please? He goes on to say, in material alterations in appearance, any repair or replacement that constitutes a substantial alteration in the appearance of the development should require membership approval, even if the cost does not exceed the 5% restriction. Could you give your opinion on that, please?
Okay, so what he's talking about in this opinion here, and what the cases are opining on, is this capital improvement language that I've been talking about. And so sometimes, and just so you know, I told these guys today, I know this is a very contentious, maybe not contentious, but heated, strong, emotional, there's a word that I want, emotional situation for you folks. Can I promise you that every single community we work with goes through the same debate when they're refurbishing their common areas? Every single community has this dialogue. This is not out of the norm, and the members want to know how much input do we have in the new project, or does the board get to make that decision outside of us? And just know that the board does take your input, no matter whether or not there's this actual vote that's taken, the board does take your input. They take it in board meetings. You have an open meeting act under the Davis-Sterling Act that allows you to speak to your board and address your board. You're welcome to write letters to management, which they will share with the board and maybe even put it on the agenda if an item rises to the level of being agendized. There you have membership meetings. You have your annual membership meeting where you're allowed to address the board. So there's many forums for you to address the board outside of an actual physical vote. And I don't want you to think that the board makes these decisions in a vacuum. Also, there's this higher fiduciary standard that we've been talking about, where even if they don't agree with the opinion, if a majority of them agree, that is the decision of the board. So a minority member of the board cannot overrule the majority of the board if the board makes that decision. The only thing that would counterbalance that would be if the board breached its fiduciary responsibilities by ignoring the law, for example. So in such circumstances, I think, you know, it's hard to look at these opinions that he puts on the internet and really apply them to your facts, because your facts are different. And oftentimes when we see the capital improvement language, I really like it when the developer attorneys, because we don't specialize in the developer side, we believe that to be a conflict of interest for our firm. So there's firms that specialize in designing these documents from the get-go. And the developer attorneys that I like define what they mean by capital improvement, because that varies from community to community.
Thank you.
So that's the answer, I guess.
Okay.
Thank you. Stephen?
Thank you, Jennifer, for traveling all the way.
You're welcome. It was a beautiful drive today. I couldn't have asked for a more beautiful day.
So I'd just like to follow up a little bit on what Herb asked you.
Sure.
And we have an unusual situation here where we have a board that is in flux in terms of Herb and I were elected last fall.
Okay.
In large part because a significant proportion of the voting membership that voted in that election were extremely concerned about the proposed building project. We are at the beginning of a new election season beginning on Monday, along with the recall campaigns mounted against Bill Waite and myself. So we are right now with a board that is not uniform and where there may be changes, and there's a lot of fear in the community that I know. I speak to hundreds of people about decisions being made by a board soon before the election which concludes, I think, November 15th, that may not be truly reflective of the community because some people are termed limited out and other people may or may not be reelected, et cetera, et cetera. So the question I pose to you is, what is the real connection here between a board vote under such circumstances where there's a lot of tumult, a lot of controversy, and a lot of dynamics going on, and any decision that the board might elect to do, might vote to do over the next 2.5 months?
I'm not sure I know what the question is, but I'll try to answer it. How's that? I think I know what you're asking, but I'm not sure. 'Cause that was more of a statement than a question. But
It wasn't meant to be. I'm sorry.
Okay. But I understand that the board is not united. They're not unanimous on decisions right now. That's pretty common, and that's actually even though it may not be pleasant for you, it's a very healthy thing, because the people who are in the majority need to listen to the minority, and it shapes and influences their decisions. Just like the people in the minority listen to the majority, and it shapes and influences their decisions. We're always colored by other people's opinions. We're always colored by other people's opinions of us, opinions of other people. We're always influenced that way. So the board influences one another that way, and it's a very healthy dynamic in a democracy to have that discussion and to have those debates and to listen to your membership. But by law, once the majority of the board makes a decision, that's the decision of the board. So a future board is obligated by law to uphold that decision. So that's, I mean, you can't just say we shouldn't make a decision because a future board won't, we don't know that the future board is going to agree with our decision. You can't paralyze yourself that way with decision making. You have to make decisions. And like I said, sometimes the board doesn't know where the hot potatoes should land, so they go out to the membership and canvass them and say, hey guys, we know we're going to tick you guys off no matter which way we go on this, so tell us what you want. And try to figure out what the community, give them a litmus test of what the community wants to see. Because sometimes I see in the community association dynamic, you see that a very small vocal minority comes off as a lion, when actually the majority of the association doesn't agree with that vocal minority, but they're just complacent. The way we say, if you want people to show up in an annual meeting, put something really controversial on the calendar, like a huge special assessment increase, because people don't come to the meetings if they're happy. They're complacent. They're happy with the way things, they're happy with the status quo. They're happy with the decisions the board is making. So the majority of the board makes the decisions from day to day, and they're influenced by the minority speakers and by the individuals in the audience and how they make and shape their decisions. Because again, the board is acting with this highest standard of care in the interest that they believe to be the interest of all the members, not just a minority.
So thank you for that response. Can I just follow up briefly? I have actually gotten other opinions from both attorneys and people who've been in HOA management for many, many years. And they actually, their opinion is different than yours, irrespective of the governing documents, because of the supersession of state code as adjudicated through case law. So I'm not an attorney, and I realize that not all attorneys agree on all aspects. So the question I'd like to pose to you is that in your experience, where you have communities that are divided like ours, have they generally gone to a member vote to resolve these, or have they generally gone the way that the board decides, even though there's huge controversy?
Well, I mean, every community has its inherent conflicts. I think you feel that your conflicts are very different than theirs. Every community has their challenges. As I told you, every time a community does a refurbishment, we have this discussion about whether or not it triggers a membership vote under the governing documents, whatever that membership vote is under the personal governing documents of that association. So I don't think you're unique in that circumstance. I don't think this situation is unique. I don't know that the board can certainly take whatever input it wants from the members. And as I said, there's constantly, the law has built in forum requirements into the Open Meeting Act. So the board is required to listen to the members at the board meetings. You have an open forum requirement, so they can come and give the board input on anything they want, whether or not it's on the agenda. They can talk about what birds fly above the community if they want to, even if it's not agendized. So, you know, the question going down to the actual vote, that really would be, if it's not required by law, the board can certainly do it. But the question is, Do they want to do it? And what would be the reason for doing it? Do they want to take on the expenditure? Large communities, I mean, I can tell you, we represent a lot of very large communities. The tail that wags the dog is the mailing costs of these votes. Some communities, it's you know, $75,000 to do a mailing. So the question is, do we want to mail out a ballot, which we may or may not consider, because you're not going to be required by law to consider that vote either. The board can disregard the vote if they want to, if it's not required by law. So the board has to ask itself, is it worth, would the members like us to spend $75,000 to get more opinion on this issue, which we've already gotten a lot of opinion on? And that's really the question that the majority has to ask and answer. Sure.
Thank you. Susan, you had another question?
Yes, but I'd like to comment that I think sort of addresses the question that Bob asked about, you know, should we have a vote even if it's not required? And your point is that, you know, we would be making the choice to spend perhaps a lot of money when it's not required. And that would be something we would have to judge whether or not that's appropriate.
Correct.
Yeah. And the fiduciary duty thing, it is the legal duty. We have the legal duty to act solely in the corporation's best interest. And by serving the best interests of the corporation, we serve all of our members equitably. I also wanted to note what Jennifer was talking about, capital improvements. Some of our sister communities who are held up as an example for us, they have language in their bylaws about capital improvements, and they deal with them through special assessments. We don't have language in our documents that specifically addresses capital improvements, and as Jennifer mentioned, it's not in Davis Sterling either. So we just need to be aware of that and consider that. And I'd like to just mention, and this is not a legal thing, but Steve raised the issue that there is a lot of fear in the community. And that does seem to be what's driving a lot of the controversy. And I think it's unfounded fear because the board has done a lot of planning in this area, and we have said over and over again that we're looking at 2 to 3% assessment increases over the next 5 years, and people don't seem to believe that. But when we made those projections, and staff works very hard to make those projections, they made them in October of last year. We knew that we were going to be doing something with our facilities, making a major investment of some sort, and 2 to 3% is what you should expect in your assessment increases over the next 5 years. Of course, we make that estimate every October just because we don't have a crystal ball and you can't see out that far. But we are expecting reasonable assessment increases and not huge special assessments. And that is the way that many communities deal with major renovations, is they do special assessments.
We're not. Bob?
Yeah, Jennifer, you said that it's the option of the board of directors to basically listen to our legal opinions from our council or not. What are the repercussions if a board of directors of an HOA, us, were to go against the legal opinion of our council and something was to happen? I mean, what is our fiduciary duty as a board, and what are the repercussions of an action of that type?
Yeah, that's a good question, because what happens, I mean, I'd like to phrase it a little bit more casually, which is, what happens when the board goes opinion shopping? Yeah, we don't like your opinion, so we're going to go shopping amongst all the attorneys and see which attorney will give the opinion we want. And I will tell you, there are some attorneys who will give you whatever opinion you want if you pay them. Unfortunately, I hate to say that. I absolutely hate to say that, but there are attorneys who will give you opinions that you want to protect you. So I think it's important to recognize where the experience is coming from, where the attorney's background and expertise is. You know, in our particular law firm, I mean, we serve on the CLAC, the California Legislative Action Committee. I serve on the CAI Board of Directors. I'm an educator for CACM. I train managers to be managers. I train board of directors. I've done this my entire legal career. Somebody who's coming by that doesn't have experience in HOAs and might do a motor vehicle accident here and something else over here, I don't know that his or her opinion would carry quite as much weight as mine would with the experience that I have. Similarly, I would not be the person to give you an opinion on a car accident, because that's not my area of expertise. So in all fairness. So I think it's really important for the board to look at who they're getting their opinions from, that it's people who are respected and trusted in the industry and understand the legal repercussions of the decision. But the board itself, let's say that the board says, we don't like Jennifer's opinion. We're going to go to X law firm, and we're going to go to the Davis Sterling law firm and get an opinion from them. Okay, and then the board decides to go with that legal opinion. Well, then the board has potentially set itself up for a breach of fiduciary duty claim, because you've gotten advice from legal counsel, you've gone against that advice from legal counsel, so you better document under the business judgment rule why you've changed direction. That's going to be really, really important for the board of directors in order to cover themselves from individual liability if they're changing the direction from what the trusted and respected opinions are that they've received from their experts.
Thank you. Somebody have a question down there, Stephen?
Yeah. So I'd just like to address an issue that Susan just raised about the assessment levels and the fear issue. I've actually sent a copy of the November 2013 Views magazine, which has the official financial reports to a number of individuals who have decades of experience in HOA management. In their view, our association financially is in not good shape at all. We have way underfunded reserves. This is one of the reasons why Cindy shares some concerns. We don't know yet the extent of our actual liabilities. The $9.5 million that's listed in the current internally done reserve study, when most reserve studies are done externally, is way low by many people's estimates. So the concern we have is that because that 2% projected increase in the assessments over the next 5 years per annum may in fact be based on faulty data. We will know, we're hoping to have the external reserve study completed by now or soon in time for the budget process for 15, but that hasn't happened. But if in fact our liabilities are not 9.5 but closer to 20 million, and this expert thought that that might even be optimistic, our reserves are funded even on the
Are you asking a question, Stephen?
accrual basis of about 20%. So the question I would ask here, given I'm just addressing the point that Susan made, do you take into account when you give legal advice about membership vote the state of the finances of the community as one of the factors in tendering a legal opinion, or are you completely focused on just legal code?
So the question is, I think, the question is whether or not the statutes that talk about getting an opinion or the internal provisions of your governing documents require you to balance the existing reserves against that decision about whether or not to take a vote. Those two things are not tied together in that fashion. The statutes and the BRE regulations and the provisions of your bylaws stand independent of those. So there are requirements for reserves. Under California law, you have to have operating and reserve accounts, and you have a reserve study prepared every 3 years, which the board is, by law, must review annually. So the board is charged with reviewing the operating and reserve accounts and describing to you as part of the annual budget where we are, giving you an assessment of your bank accounts every year. So every year you guys annually also get that information. So as part of that too, the legislature is always trying to give the consumer more information. So they have requirements under the Davis Sterling Act that there be a chart that's kind of really reflective of just the bare bones. Where are we with our reserves? Are we underfunded? Are we overfunded? What are we going to do with, if we're overfunded, where are we going to shift that money? If we're underfunded, how are we planning on in the future taking care of those items? So at this point, your board has determined that they need to do some refurbishment of the facilities. I can tell you the first time I walked in this facility, I knew right away that this place was not ADA compliant. And has anybody heard of the squeeze in Sacramento, that whole lawsuit where the attorney in the wheelchair came in and he couldn't get into the squeeze in because the charm of the squeeze in was that it wasn't wheelchair accessible. It was in a small little tiny facility that couldn't be made ADA compliant. And he sued them, and that facility had to be torn down. Now you may know this as an architect, the story of that. Now, that individual was required to comply with the law because this individual wanted to be served, and there's nothing wrong with this. But when I came into this facility, my first question as an attorney is, when is that guy going to visit you guys? When's he going to come to your community? So I think it's incumbent upon the board as part of this decision, not getting tied down in all of the facts of, we need to plan for this. Whether we do it today, tomorrow, are we going to kick the can down the road to another board, or are we going to do it now? Because once you start kicking the can down the road, it now becomes what we call deferred maintenance. And we've worked with communities that have significant deferred maintenance. There's one in Sacramento that we have where the board can never agree to increase assessments. They can never agree to take out a loan. They're paralyzed because they can't, and they're only 4% funded in their reserves, and they have a lot of trip hazards and a lot of problems. Nobody will represent that community because that board, we cannot force that board to make the right decision. They've been in and out of court, and they still haven't made the right decision. The 6 minutes that I represented them, we got a special assessment in place. That board was recalled, and they wiped out the special assessment. And then I quit as their attorney. Dear John, I am no longer your attorney. Okay? So I think, I think, again, I wish I was speaking after you, because he has all the facts. I don't have all the facts for you, but I'm guessing there are facts that support my, layman's opinion that this building is not ADA compliant. And there may be other areas that are not ADA compliant, and there may be laws that apply that subject you to liability. So there's a lot of other decisions other than the nuts and the bolts of, do we have 60% funded in our reserve? Do we have 12% funded in our reserve? There's a lot of, this is a very complex, as you know, complex decision. There's a lot of facets to it, and the board's trying to get the best advice it can from its respected experts and make an educated decision. And I think that's a good thing. The board's doing the right thing.
Thank you.
All right, let's do one more question, Susan, and then.
Okay, it's my understanding that part of legal review on a process or when you're representing an association is whether or not they're following their own policies. And that would, if we're following our own policies, then that would help you support or protect the board in whatever comes up. Is that correct?
So if we're going through a breach of fiduciary duty claim, one of the things that the attorney on the other side is going to raise is that the board doesn't do things consistently, that they are haphazard in their decision making. They only do enforcement in this area of the community. They don't do enforcement in that area of the community because all the board members live over there, or they have all these internal policies in place, but they only adhere to the policies they like and they ignore all the other ones. So absolutely, that's going to become Exhibit A in a lawsuit involving the board of directors for breaching its fiduciary responsibility. We have provisions in place that we're required to follow, and we did not follow those requirements.
Okay, if you'd just give me a moment to read our policy on replacement reserves. I'd like for folks to understand this, and then I'm done. The association will fund reserves so current owners contribute adequately to future costs of ownership of current assets. This ensures that future buyers of property are never faced with the need to fund costs deferred from prior years. Conversely, the association will fund reserves in such a manner that current owners are not subsidizing the costs of asset ownership for future owners by excessive contributions to reserves. So I don't know if there's anybody who in this audience who would like to start paying a lot more money so that people who own property in 20 years have got enough money to pay for facilities.
So what's your question?
It's not a question, it was in follow-up to the fact that if we are following our own policies, then we have some sort of protection, as board members, that we are indeed, we set a policy and we're following it.
All right. What's the deal on the question cards? Or do we have somebody out there handing them out, or?
They were located in the back.
Or they are located in the back? All right, so we're going to take a 5 or an 8 minute break, There are question cards. If you have a question, if you would please write it down on the card in the back, hand it in, and I guess it's probably going to take more than 5 minutes, so 15 minutes. There are cookies in the back room as well.
It's actually how the attorney-client privilege works. So the court works with my client. My client speaks to me through the court. So the members, well, the board has to. I can't waive that privilege. I would be violating my ethics of arbitration. So, yeah. So, right. Well, there's certain things that I can tell you, and there's certain things I can't tell you.
Art, the answer to your question is they can't be transparent on every single item because then it's a corporation. What corporation does? What corporation does? Can they discuss salaries? They are transparent, but there's a difference in being a democracy and being a corporation. We are a corporation. I mean, I can have a private conversation with you, but to disclose every item of everything, that's why you elect them to represent you.
Yeah, like our Congress.
Yeah.
Good, they're doing it.
Same thing.
That's what bothers me. I know.
No.
I know you're coming from.
Yeah, well, they were elected to make decisions, and then they, okay. Hi. Hey guys. No, we're gonna take comments. No, we're not gonna beat up these guys. Yeah. This is we asked you to write down one of your questions on a card. This is a forum, Kay. This is not an open meeting. It's a forum to give information. So put whatever question you have, and we will address it. Yeah, but it's well, then you can forward it to me, and I will forward it to Jennifer. But we're not. This isn't meant to be doing grandstanding or politicking. It's information, and I'm not stating that you are. I'm not.
Busy. I actually got here late, so I'm kind of trying to catch up. But I came in when the attorney was speaking, and I guess I'll catch up with the video later. But she was explaining then our board's ability to borrow money. Is that the discussion?
Thank you. Thank you very much. What happened? I'm just sorting them, that's all. I'm trying to put like items together.
Put them in a hat and have her talk.
We might have to because I'm not seeing a lot of the same question. Oops. I don't know, who was it? Where did she go? Cindy, do you know? Oh, thank you. I need my glasses on.
She was, I was complaining that I did not get a notice. Anyway, I did not read any place that the attorney would be here asking the question. And Cindy said that it went out by email.
It did.
But to whom did it go? We've been at the very first, we've been listening.
Are you getting our clear lines of communication emails?
Not that I know.
Okay, we need to make sure we get your email address.
And how do I do that?
You can give it to Jim Freeman, or you can just write it down and I'll get it to Jim Freeman.
Diane, thank you very
I
much.
think that's a lack.
What's that?
I was very is that people do not see it. I think that's a lack of.
Again,
It's also posted at the, it's
It's
also posted at the
posted?
bulletin boards and on the website.
they are there.
Okay.
Thank you. And I invite you to come in and see us, Kay, so we can go over the financials so you can better understand.
It does
I
say
know the
presentation
staff
by Jennifer
has been
Vidal
given
and
this task. We're not one way or the other. We're just kind of doing our jobs.
You're right, it doesn't say that.
And that's what's critical to do it for the public. Where's Jim?
Jim Freeman is right here in the white t-shirt.
No, the point is,
I wonder if I could ask a favor.
Sure.
It's an open crowd.
Yes.
And the board members are not speaking into the mics and we can't hear them.
Okay.
They just talk. They just have a mic.
I will remind them. Thank you. Absolutely. Absolutely. No problem. Bill, this really nice lady, they're having trouble hearing in the background, so if the board could please be sure to speak into the microphones. They're having trouble hearing. Oh, thank you.
You know, but then no matter what you say, they're still not going to a certain view. That's right. No matter what.
And life goes on.
Yeah, you got that right.
I'm down to 25 minutes left.
She has 25 minutes left.
I have, right now, yeah, it's 5 after 3, I have to be done by 3:30.
These are, none of them are the same. Thank you very much.
The lady that we escorted out, do you know who she is?
I didn't see her. What does she look like? think we should ask Jennifer which one she wants to get.
Okay.
Because they're all really
Make a
different.
decision in about 2 minutes.
Can you find Jennifer? Do you have a card? Sure, okay. I think one more water. They're not the same, so you may just want to peruse the ones that you know that you can answer, because there's some that you're going to go, oh boy, we shouldn't answer that one.
Okay.
This is you answered this already, but maybe a clarifier.
You're between me and my cookie.
I'm sorry.
No. I'm kidding. It was a joke.
It's all right, but I'm trying to.
Not those specific facts.
Okay, this one wants to go further on 1105.
Yeah, he told me about that. He came and told me what he wanted me to say.
20 minutes, yeah. Ready to go.
This isn't even a question.
Get started, so
These are more questions for the board.
we got a couple of them, and then that's that one you want to give answers.
Right.
I think you can answer that.
I don't think we've gotten that far. We haven't gotten that far. The question that you and I talked about.
Like this one.
That goes back to the thing about the
I've talked to Bill Lee. He's going to talk to all the directors. Somebody else mentioned in the back of all the public hearing. I'll go first and ask them. You're welcome. Just a quick question. I've had a couple of community members that have
what?
trouble hearing when you two speak. So if you could please be sure to use the mic, especially because we have so many people.
Think about the Hartman facility. Well, I was speaking to this building specifically.
If you say something, you can use the mic.
Yeah. Sure.
If we get more than we can take. Let's start off with a couple of
Yeah. Well, what do you want? I don't know yet which one you want to answer. You want to answer that?
about 3 of them, and then
Okay.
right now we have 20 minutes to answer them.
I thought some of them would be similar, you know?
By the way, I asked Connie if she had permission to solicit sales. That was a good hit.
Sure.
This is ridiculous because we do notice our meetings.
Right.
If we were to update our bylaws today, well, we can't without a membership vote.
Right. That's easy.
I don't have these questions, so I can't answer them.
No, I can't whistle. I wish I could. Please take your seats and so we can get started. I've already had a couple of issues where people are having trouble hearing in the back, and so I appreciate the cooperation of everybody back here, and I will try to get the board members to get the microphone closer to their mouth when they speak as well, so to make it easier for everybody here. So it's imperative that we let people talk so that this information can get out to everybody and everybody the same. Thank you. And we're down to about 20 minutes now to answer questions. So Jennifer, when you're ready.
Oh, sure.
It's taken a couple extra minutes. We thought that we would have some repeated questions, but it seems like there's that's not the case. So trying to pick out what she can answer.
Yeah, because some of these are statements rather than questions.
Yeah.
So it's hard for me to, I can just try to get through them.
Well, you can't answer statements.
So I'll try to get through the ones that I think are questions. I apologize if I'm not reading them the way that you want me to read them. Can the board close the open comment session even if not all members have had a chance to speak? There is, under the Davis-Sterling Act, an open forum provision in the board member meetings. When the board is meeting, the board is conducting association business. The members are entitled to attend those meetings, listen to the board, discuss and deliberate items of business on the agenda and within their jurisdiction. And the members are allowed to have an open forum, a comment session that is not restricted to the agendized items. And the board is required to have an open comment session, but there's no time that they are required to have that open. So most boards will have a set time that they'll take questions at a meeting, and if they can't get to all of the questions at a specific meeting, then they will close the session and the members can come back to the next meeting and pose those questions. But you're not required to have a meeting open for member comment until all members have had a chance to speak. That's not a legal requirement. This one says, is a board member's fiduciary duty to the best interest of the membership or to his view of the best interest of the corporation as distinct from the membership? The fiduciary responsibility, the business judgment rule states that board members are required to act in a manner that they believe to be in the best interest of the membership as a whole. So each individual has that fiduciary responsibility when they're engaging in board business. So when the board is voting as a majority, all of the board members have that standard, that they're putting the members' interests as a whole, the entire community, the majority of the community, ahead of their own personal interests. That's that statement. If we were to update our bylaws today, how would you address the board on defining capital improvements and carrying out such projects in the new bylaws? As I stated earlier, the requirements of the capital improvement language are part of the Bureau of Real Estate requirements for new developers. The developers are required, and if any of you are original owners here, do you remember getting a white report? Nobody? Okay, a long time. Yeah, that big stack of papers. When you buy in a community association in California, you get a bunch of CC&Rs, bylaws, articles, and you also get something called a white report. And that's the developer's disclosure report. And so as part of that requirement to get the authorization to sell and to issue that white report, they're required to put certain things in their documents. And the BRE will kick the documents back if they don't follow all of the regulations under the BRE. One of the regulations is that any capital improvements over 5% of the budgeted gross expenses for the fiscal year must go to membership vote. So that's where that language comes out of. That language does not come out of the Davis-Sterling Act, which is another question somebody posted, which is similar. Where does the provision that states that a 2/3 majority vote is required for expenditures over 5% of the annual assessments appear? Davis-Sterling Act or bylaws? Well, that kind of blends a couple different requirements. I talked about the BRE regulation with the 5% for capital improvements for developers. There's also a provision in the Davis-Sterling Act that I talked about, which may have gotten this individual confused, which is for special assessments. If a board is going to impose special assessments, which in the aggregate exceed 5% of the budgeted gross expenses for a year, a fiscal year, then the board is required to get membership approval for that special assessment. Similarly, if they raise the regular assessments more than 20% in any fiscal year, they are required to get membership approval for that assessment. In case of a recall, does the board replace the empty seats? I think I addressed this earlier. The board, under your bylaws, fills the seats. Majority vote of the remaining directors, or if there's only one director left, if it's a recall that wiped out everybody but one director, that one director would place the other seats. So, if 1105 addresses only the new construction process, why is it still in the bylaws? And then it talks about the Adams-Kessler opinion. I think that the Adams-Kessler opinion is based upon the capital improvement language out of the BRE, because those cases that are cited in support of that opinion talk about that language from the BRE regulations. Why is it still in the bylaws? I'm not sure why it's still there. We were not your legal counsel when these were restated originally. So historically, I can't answer that question, but it could have been taken out, and it can still be taken out in a future membership vote. But in order to amend the bylaws or your CCNRs, we have to take an actual vote of the membership. That would require a majority vote of all members in favor of the revisions to the bylaws. And I can tell you, if you think this facility issue is difficult, I can tell you redoing the documents is also very, very difficult. So I don't recommend taking this all on at one time. It's a lot to take on. Is the board, I'm sorry, I can't read all of these. Is the board required to give all information, okay, is the board required to give the membership everything it has, basically, when they're making a decision? Or are they only required to give them certain facts? Well, as we talked about earlier, I think this goes to the legal opinion question. The board holds the attorney-client privilege. I do not hold the privilege. The board is my client. The corporation's my client. It speaks to me through the board. The individual members are not our client. If you wanted to obtain your own legal counsel, you could do that as an individual, but that will not be binding upon the board. So when the board takes our legal opinions, they get to decide whether or not to share that with the membership. There may be reasons for them to not share it with the membership. So from time to time, they may take pieces of legal opinions and share them with you. They may ask me to rewrite a portion of a legal opinion and share for public consumption so that the members can read it. That's what boards typically do when they want to disclose all or part of a legal opinion that the membership is concerned about, but they are not required to turn over every legal opinion to the membership. I think this is a statement. It just says, is it not more important that sitting board members be left in place to hash out their differing opinions and those of the membership rather than dumping that responsibility back on the membership via a recall election? How will you consider the voices of parents who have committed to their children, if not by mail vote, with the internet? It will be considerably cheaper. I think what they're trying to say is, why can't we do this vote by the internet? Any required vote under the Davis-Sterling Act or under your documents has to go through a mailed process. Unfortunately, the California legislature has not caught up to the internet, and they do not have a current provision in place for us to legally hold our elections by internet. And the reason that is that if we drop a piece of mail into the public facility, the U.S. mail, it is deemed received the minute you put it in that mailbox, because a government entity takes the mail from point A to point B and delivers it. That is a third party that can verify that the mail was delivered, whether or not you actually receive it, but they can verify that it's delivered. The internet, once you hit send, there's no third party to verify that it was actually sent. And as we know, people change email addresses, they change jobs, and it just becomes very, very difficult for the board to legally hold a valid election via internet because they don't have the capability to verify that all of the emails were sent and received. So until the legislature gets its arms around that issue and adopts the legislation to allow us to do it, we are required by the Davis-Sterling Act to do it by mail. And it's very expensive, as I noted before. Somebody asked about 1105 of the bylaws. I don't know if everybody's familiar with that section. So maybe we can read it to you. Do you want to read it? You feel like it? They're probably sick of listening to me talk, so why don't you read it? It's right
Actually, okay. 1105, limitation of powers.
Cindy, can you get closer to the mic, please?
Section 1105, limitation of powers, no contract with the possible exception of the management contract shall be entered into which binds the association for a period in excess of 1 year without reasonable cancellation provisions included herein. The association shall not incur debts in excess of 5% of the amount of the total regular assessments per year for the purchase of real or personal property, the insurance of bonds, and wait a minute.
Issuance.
Sorry, contacts. Or mortgage any of its property without prior vote of written consent of 2/3 of its members entitled to vote.
Okay, so this individual has said you've addressed one of the 3 stipulations within 1105 that would trigger a vote. And this person wants to know whether a loan would be for the purchase of real or personal property, excuse me. And then it says you've not addressed stipulations 2 and 3, whether this is a bond or debenture or a mortgage. And then they state their opinion that they think that a loan would be a debenture. So the question is whether or not, if the association incurs debts in excess of 5% of the amount of the total regular assessments per year for the purchase of real or personal property, or for purposes of the issuance of bonds or debentures, or for the mortgage of its property, they are required to get 2/3 votes of the members entitled to vote. So the question is whether or not the project would constitute a purchase of real or personal property, whether or not the project would constitute the issuance of a bond or debenture, or whether or not it would constitute a mortgaging of common area property. Well, I've already addressed the common area property issue, because that one, you can't mortgage common area property because it has a 0 tax basis. So there's nothing for the bank to put a lien on because it has a 0 tax basis. So what the bank will look to, as I stated earlier, I thought I answered this question, is the bank will look to whether or not your governing documents require you to get a membership vote. So they're going to ask for a council opinion from the general counsel for the association to the bank as to whether or not we believe that a membership vote is required under the circumstances. So this question is really premature because there's no loan on the table. There's nothing to consider. We don't know what the requirements are at this point. So this is kind of in a vacuum answer to that question. But once the bank were to present a loan and that was analyzed by the bank, then that would be reviewed by the legal counsel for the bank as well, and then the bank would decide whether or not they needed to go out for a membership vote. And that would be their decision. So,
sorry,
oh.
please.
Okay.
This is just her going through that. Those comments, if you have any other questions to ask, please write it down and put it in the back. I'm sorry. I made that rule right straight up front. Thank you.
Okay, this says Jennifer Jacobson, this, again, I think a statement. Jennifer Jacobson made several statements outside of her area of expertise supporting the board's current course of action. How would she can defend her purported role as a neutral expert? Well, I don't think I ever said I was a neutral expert. I think I said that I was the attorney for the association, and my client is the association. And I try to give the board the best possible legal advice I can give them based upon the facts that are presented to me and based upon the state law and my knowledge of the same, and based upon working with 1,000 other communities in Northern California and Northern Nevada. So I do have the position of an expert. I've been declared by the court system in California to be a legally recognized expert in the area of common interest development law. I have testified in court cases. I have been deposed, and I have appeared in trial to talk about my interpretation of the law, the application of the law to a specific set of facts. So yes, I am considered an expert in the state of California. I don't think I'm going to answer that question because that's my opinion and I don't think it's valid or relevant, I should say. Are you contending that it is illegal or unethical to allow members to vote on a large expenditure? That is not what I'm saying whatsoever. How was that answer? All right. How can the board act as our representative when only 6% want the building project and 94% want a vote? I don't know what that means.
Quiet, please. Thank you.
This person just says, there appears to be a disincentive. There appears to be no disincentive for a community vote other than, you guys all have to write bigger, please. I'm getting, there appears to be no disincentive for a community vote other than the cost of mailing. In a community our size, this is around $10,000. Wouldn't that be a cost-effective insurance policy against future possible litigation? I'm gonna tell you something that my partner and I tell people all the time. Anybody can sue you at any time for anything. There's no guarantees against litigation. A lot of lawsuits are frivolous. We all have friends who have been sued frivolously, or maybe they've sued people frivolously. But anyways, but we all know that that can occur. So there's no way the board can completely insulate itself from legal liability. And when it's a contentious issue, there's going to be people on both sides of the issue. If it's a divided issue, the boards are going to always have people on both sides of the issue threatening to sue them. And there's no guarantees against that. Is the board the only entity that can initiate legal action on behalf of the community? Yes and no. There's a provision under the Davis-Sterling Act. It was previously 1354. They changed all the numbers this year, and I unfortunately don't have them all memorized yet, but wherever 1354 appears in the new act, in the 4000 to 6000 series of the Civil Code, there is a provision where you can sue on behalf of yourself as an individual in the community association if the association fails to enforce their own governing documents. An individual can bring an action in their own name, in their own right, to enforce the governing documents, and if they're the prevailing party, they can recover legal costs. However, there's case law that the association does not have to pay those legal costs to the members. In other words, if you're the prevailing party, if we're having a disagreement, we're neighbors, we're having a disagreement about my dog barking, and the board doesn't do anything about it because it's a neighbor-to-neighbor dispute, and she sues me and prevails, I have to pay her attorney's fees, not the association, if that makes sense. So basically you step in as a member into the rights of the board in that type of litigation. Is it a legal requirement that all members of a homeowners association board be noticed when the board meets? All board members are going to be noticed of the board meetings. In fact, you guys probably schedule the board meetings at your board training session after the board's elected for the whole year, and they try to get all board members to attend every board meeting. The only time that the board may excuse a board member is if that board member is subject to discipline. There's conflict of interest laws. A board member is declared to have a conflict of interest if they're being censured by the board for violating the governing documents. If they are applying for an architectural application, they can't vote on their own application. So there's certain circumstances when, yes, a board member would be excused because they're stepping into the shoes of a member rather than acting as a board member from the board decision in that case. I don't know that was a question.
Well, it is actually. What would trigger a vote is what he's trying to, that's the question.
I think we've already answered this question. Yeah, if there's one of the circumstances in 1105 that occurs somewhere down the line, that will trigger a vote, and the board will take the vote if it's necessary at that time. Similarly, if you trigger what used to be 1366B of the Civil Code, which is the membership vote for regular or special assessments, the vote will be taken at that time. So those would be the circumstances that would trigger a membership vote. I thought I already answered that. I was trying to not repeat myself too much, but in your experience, have you found a community that has downgraded their facilities and closed the golf course that increased home values? Okay, this is somebody who disagrees. They believe that Adams Kessler's right and that you should take a vote based upon Adams Kessler. That's the same question I just answered. This says, could we, our members at large, have a concise, clear, written clarification of their bylaws relevant to contentious issues, which will be available to those not present today. So the question is, for those people who are not here listening to this presentation, the forum has been taped. Okay, so that's the end of the questions.
Good. Just made it just under the wire.
I just want to clarify, I think the question was, is a loan a debenture? I think we need to understand that a debenture is a corporate bond, because people are thinking that a loan is a debenture. And so could you clarify that?
Well, again, this is going to be what the bank's going to require. I'm not going to write the requirements for the bank. The bank's going to write its own requirements before they're going to give you money. They're going to tell you if they believe it's a debenture or not. And I'm not going to disagree with that opinion, because they're going to be the ones who are going to be paying for that loan to give you the money. So that's going to be a decision that's made down the line.
Just clarify for me that most corporations can issue corporate bonds in order to raise money, correct?
Right.
So that's what a debenture is, corporate bonds that are issued and sold to investors, correct?
I can't speak to the intention of that language in your documents, again, because I didn't draft these documents. I have no idea what the attorney was thinking when they put that in there, what the circumstances were, what drove that to be pulled into the documents, where that language came from. I know none of that. I have no factual history for you to explain why that's there. So I can just tell you, if a bank is making a loan and they believe that provision to be triggered, they will require you to get a member vote before they give you the loan.
All right, we're running out of time here, so this is the last question.
Jennifer, have you ever received direction from either this board of directors or from HVLA staff on what opinion we want you to issue on any subject?
No, not to my, I mean, I get direction. Basically what the way I receive a assignment is the board decides to have an issue reviewed by council. They instruct staff, and staff comes to us and says, the board would like a legal opinion on whether or not they can paint the clubhouse pink. Can you please provide a legal opinion under the governing documents?
But the board has never directed you what to issue in your
That's what
opinion.
she said.
What we asked.
Yeah.
Well, what the board, I mean, not your specific board, I don't recall you folks doing that, but other boards may say the board is leaning in the direction of this, and they were wondering if there's any liability associated with this train of thought. And then we'll outline for them, well, here's the 3 different ways you could do this, and here's the one that we recommend, and here's the one we don't
Right.
recommend, and, you know, kind of give them some guidance. Because right now, we're assisting as risk managers in trying to help the association avoid litigation and to do the project legally.
All right, thank you. If anybody else has any other questions, I'm going to release Jennifer here and change the topic under discussion. But if anybody else has any other questions, the cards are still back there, and we will do our best to get either posted on our website or something else an answer to your question, if not direct. So I want to thank Jennifer for her presentation and taking the time to come over here to help us. And I want to thank everybody here for coming out and listening to her quietly so that she could actually get her point across for everybody.
Yes, you all get an A+ on your attendance. You were very, very polite. Thank you.
Thank you. So now, are you ready? Heather? Or say it? Push a few buttons. For everybody, this is Greg Dinello from Williams Plus Patton, who's been working on the Hartman project and the Community Center project, our facilities projects here, and is here to give us a further presentation on our facility. Greg?
Well, there we go. Can you all hear me? Thank you. And Terry Green, most of you have met Terry or seen Terry. He's done these presentations with us before. He is in China this week. He sends his regards and best to the board and apologizes for not being able to be here. Okay.
Jim, can you turn that up a little bit, please?
And I got to apologize ahead of time. We're a little challenged in this room because the amount of great daylight we're getting is going to affect somewhat the presentation. Is anybody not able to see this very well? There's, I knew that. If you had a chance during the break, some of these exhibits are out on display out there, so you can take a little closer look. Most of them are in black and white, but in a larger scale. Some of them are in color. Want to go back and do a little bit of history, if you will. How many were here last, I think it was April we did the last presentation? Terrific. Not a lot has changed, if at all, on the site plan or on the building plans. What we were asked to do after that last meeting was to go back and look at the exterior elevations, because we haven't approached really the aesthetic of the building at that point. So I will briefly go over the site plan. Unless you can't see it very well. Is this going to be problematic for everybody? Okay.
Tell the sun to go down.
Yeah, I really don't think that that's going to help all that much. It'll help a little bit. Please.
I'm at a loss here. I think what I'll do
Hi,
is I'll
Greg.
grab a couple of the boards out there and see if we can't work with some of that to some degree. So I'll be right back.
We don't have a copy machine here, do we? We have a copy machine?
You can come this way more. I think so, because they're going to have a couple of them.
Flip them around as we need them.
What you might want to do is move it closer so they can see better.
Okay. Well, we've got a site plan up here, but the floor plans are here. I don't have an. I gotta apologize to everybody on my right. We'll probably have to do this a couple times. One for the. Can the board see most of that, or is that?
Yeah, we can see enough.
Okay. So on the 27th, there was a site plan presentation. We came in, and it was basically a revised version of what had been presented in the previous meeting. And what we've done is off of Hartman Road, there's a main drive that comes in, and it leads to a central circular courtyard that's the primary focus and primary entry to the building and the site. There's some short-term parking up front and longer-term parking out on the spline here. As you enter, there's a drop-off area for the event center, for patrons of the restaurant, for golf users, and for the event center. As you enter the building, it's basically organized in two elements. On the right side is the golf operations, and on the left side is the restaurant and the event center operations, the meeting rooms. We still have 3 tennis courts, and in this scheme we were showing a 4th tennis court across Hartman Road and some parking associated with that. This building, relative to the existing, is located further toward the lake, or the pond, if you will, and that's been done for a number of reasons. I think we've mentioned a number of times that you've got such a great view up the fairway from the restaurant, and a great view to the 9th in the late afternoon. The sun and the shadows coming down that fairway are just going to be gorgeous. We also wanted to expand the ability to have events in the picnic area. And I think if you've been here through previous iterations, we had suggested rotating the driving range to try and get some additional length out of it. And because of a number of issues, we've gone back to basically its current orientation, but have lengthened the driving range. And it's currently probably at the very corner of the existing Hartman facility. So that was another reason for pushing the new building further out into the site. I'll get back into the floor plan. Again, after you're off into the drop-off area, you enter the building into the lobby, which would then take you out onto a dining patio. To the left, you can get into the lounge bar, or further left, directed into what would be the new restaurant. And then there are 2 meeting rooms that are could be one large meeting room or divisible into 2 at this point, with a total seating capacity of about 144. So that's designed to accommodate a golf tournament capacity. There's also an outdoor called meeting area, but it's outside, and currently planned to have a roof cover over it with walls that in the future, if it became necessary, that could be enclosed and be utilized as indoor space also. It also initially works great for an event stage for the event area. And that's out in this direction here. So you have outdoor dining, or bands, presentations could be done out in this covered section, focused on the event lawn area. So that's kind of where we were in April. The board asked us to go back and start going vertical with the project. And if you were here again previously, we had shown some images and had them out in the lobby, and everybody was able to go out and put some comments on what they liked or disliked about what we had at the board at that time, or on the boards. There was a lot of feedback about our examples that had broad roofs. There was a lot of positive feedback on examples that had stone and wood siding and batten siding on it. And I again apologize for the display here, but 11, 23, and actually the image of your stone building up down by the administration building were very resonant to a lot of the comments that we had. So that's kind of where we started our vertical aesthetic for the project. Well, what we have today are actually 2 schemes that are very similar. The first one, and both of them have similar geometry to them, we're trying to work with broad roof planes to pick up on the agrarian nature of Lake County, and again the stone and the woodsy feel of the project. You'll notice some craftsman influences as we turn the corners on the elevations. So this is an image of coming through the courtyard, the entry circle, and hitting the drop-off area, where you'd be welcomed by a very gracious and well-lit, a lot of windows into the lobby space. This is the stone that we're picking up on. To the right, you could get over to the golf operations, and to the left, difficult to see in this view, but That's where if you're having an event, weddings, other meetings could be accessed from that side of the building. So you wouldn't be required to go through the lobby if that was a desire. This elevation really driven by board and batten siding. We're looking at a metal roof and stone for this aesthetic. This is a view from the golf side, from really where the putting green is at. As you're coming through the lobby, you could come straight out under this covered area, which has outdoor access to the bar lounge. And the deck sweeps around to the front of the restaurant and then again off the side along the 9th green and faces the meeting room. So those meeting rooms could open up to that deck and have, in good weather, that we've got about 9 months out of the year, the ability to expand those seating operations from the meeting room. And that would be the view at the starters area where they have a good visual access to the first tee, which is off back behind us to our right. This is looking from down the 9th fairway as you approach the green. Again, the restaurant and outdoor dining, very gracious covered area that even in the off season could be heated or misted and kept at a very decent temperature for the users. Radius section out in front of the bar, and this is the dining area out past the meeting rooms. We're trying to keep a lot of sun protection from our north elevation, getting ourselves good solar protection on the windows. The other benefit that we're looking at because of the size of the roof and the having large roof forms is the ability to get photovoltaic energy generation out of that as we move forward. And this is a little vignette from the event lawn, which is just about where it is at now. Again, having that future enclosed meeting space that is open now, but creating apertures that could be filled in the future. But suggestion of having a band up here, turf area, and we're not showing it now, but this has been discussions about being able to have barbecues and being able to service from this back door from the kitchen itself, so events could be catered by the event center. This is what we're calling Scheme 2, which again is very similar in the geometry of the first scheme, but we're using suggestions of plaster with wood, board and batten above that. Plaster, a little bit more durable material, a little less maintenance on it, a little more initial cost. So that was one of the considerations in developing this. And relative to cost, we've tried to limit the amount of stone we're showing at this point. But as we go further in the design process, we may be able to add some stone, detract some stone. We may need to revise our roofing from metal roofing to composite roofing, but there's a lot of things that we can do to keep ourselves within our budget. The building size over time, I think we've gone from 14,000 some odd square feet, and we're down about 10,500, 10,700. So we put the building on a little bit of a diet. The parking lot's gone on a little bit of a diet, so we're trying to save some construction costs in relative to that also. Same view from the golf putting green, again with plaster and wood. And across the lake. And from the event lawn. Same views. So that's what we've done to date since our last meeting.
Super. Thank you. Once again, I'm sure there are people out here with questions relative to this. So we're going to take a short break. And then if you have any questions, please get a card, or if somebody's handing them out, so somebody go back and be available for cards and write down your questions, and then bring them up to Cindy at the desk, and we'll try to go through some of those questions.
Build it and they will come.
That's the one I would say.
Yeah, unfortunately, I have to be. It's getting a little better. How you doing? Good to see you. What can we do? Things are good. It's just in meetings sometimes things get out of control. Has to be, right? Yeah. I like my body. Yeah. Thank you. I know. We just kind of had a really busy time. Budgets, recalls, elections. I hear you.
start, Cindy, I start this a little bit differently. I'm going to have the board ask questions while you sort through them.
Okay.
And that way it'll kind of keep the emotion a little bit.
And some of these I can answer, so.
Okay.
He may not be able to, that's just.
And I expected that.
Yeah, okay.
But-
Suzanne,
And
hi, nice to see you.
Good to see you too, my dear. Good meeting, very good meeting.
Yeah, we're getting there. Good, I got your texts and stuff. I was gonna call you a little later. Look who it is, you made it back.
Yeah,
You came back from Washington? Yeah. Hi there, thank you. Anybody more? Hi.
They're engaging in a conflict that is possible using
That's what I can't understand. Hello, hi Joan, how are you?
around you. Do you see young parents here?
Good
We all
question.
know that there are a great many younger families here. How will their votes be heard? They don't have time to show up.
That's the woman who just attacked me.
They need to receive mail and opportunities to show their voices. So I think it's plausible and the right thing to do to pose questions to the community as a it's not a question, it's more of a suggestion. Yeah. You're doing a good job, Ms. Sergeant.
I'll tell you, I like Detective Joseph.
I like her too.
She's like, she saw something happening and she was right there. So yeah, I like it.
I don't even know that woman. I don't even know that woman. Did you see how she came at me?
I didn't see exactly what she said, but now when we have these meetings, this is how we're going to have to do it because I want to see everything. So I'll be your bodyguard.
And she's like big time. I like that.
Yeah.
You have one.
Go for it. You don't eat that stuff? Oh, you don't need it. You want it, but you don't need it. Balance of wants and needs, right?
I just took out 2 cookies. I did
You just took down, oh, I love cookies.
That was lunch.
Cookies, ice cream.
Okay, let me get with him so I can start giving him some.
Yeah, it's exactly.
Thank you. Thank you. Do this a little bit different than I did the first time and try to help it go a little bit faster. So while they're sorting through cards and everything like that, I'll go to the board questions, and we can start with the board questions first, and then by then the cards should be sorted, and then we can go to some of those questions. So I don't know which end I started out with. Susan, you first last time, so I'll start out with Stephen Greenberg first this time. Stephen, do you have any questions?
A quick comment and then just one quick technical
Everybody hear him?
I'm sorry, can you all hear me now? My apologies. So it's a beautiful design, Greg.
Thank you.
You know, I think it would really work very well here. Sorry, I think it worked very well in terms of the physical layout. You know, I think we've addressed the financial issues before, so I won't address those. I have a technical question about what is inside that looks like there's room for square footage under the eaves, or is this all supposed to be all open like in this case?
We haven't gotten that far yet, but we
I see.
would try on the to get as much space as we could out of the meeting rooms, the restaurant, the bar, all within budget constraints, because an open ceiling like this is definitely more expensive. But you also want to look at things like acoustics and daylighting and make sure we get all those combined within those spaces. The open eaves in the exterior, the one off the meeting room, which we're calling that event deck, is likely to be open like that, and then in the future we could drop it down. And that's meant as a future cover. Now that is something else that if budget rears its ugly head, that roof could be pulled back and we do something more of a temporary type of structure above that, or a trellis, and the roof comes as you grow into the building itself. So those are budget strategies that we use to help keep ourselves in line.
So did I hear right that the current square footage is 10,500 to 10,700?
We're 10,262, but that always has some flex in it. It's based on exterior walls, and as we start adding finishes and things to that, that number tends to creep or go down a little bit as we move forward.
Thank you, and thank you for driving all the way here from Roseville.
Yeah.
Beautiful drive. A little cooler than Sacramento today.
Again, these are this is still in concept form. It's not in final form, and no final decisions have been made. Herb?
Yeah. Thank you, Greg. Could you please tell us which specific items were used from our food and beverage study to develop your vertical elevations, and which items that were not considered, please?
We actually haven't had advantage of getting the final food and beverage study. What we worked with initially on the plan a couple months ago was, I think his name is Jim Mitchell, was a consultant to the food service person. And we did some changes relative to the kitchen layout and the bar to increase functionality. But as Bill has mentioned, this is all conceptual at this point. So we would be waiting to get the final food and beverage study and see what those recommendations are and how it impacts what we've got so far.
Thank you.
Herb, I'd like to just jump in and say that the survey that Jim put together is finalized, and we got our numbers back as in Friday of last week. So we're putting that in a package for the board to view.
Thank you.
You're welcome.
Bill? You don't have any questions right now? Bob?
No.
Susan?
Thank you very much, Greg.
Yeah, Greg, we were at Williams Plus Patton's office on Wednesday. Cindy and I went out because Cindy had some concerns about how the kitchen was designed and stuff, and she's got an extensive background in resort management, food and beverage, and hospitality. So we did some SketchUps, and they gave us some other ideas. Those are not incorporated yet, right, Greg?
That's correct.
Yeah, because of just limited time. We were just there on Wednesday. But I thought that the what's different about this? Because what we were sketching on when we were at your office Wednesday was a little bigger. It was the 11,000 square foot one. So is that?
You know, we
Is that one
just
of these
noticed that
others?
difference. There's two
What-
plans that, there's like the Where's Waldo scenario, which is different here.
Yeah.
And
Okay, well, they were pretty similar, but we were talking about moving the bathroom abutted up against the kitchen. We were talking about moving the bar back because of the fact that nobody was happy. I'm pretty sure, if I remember correctly, nobody was happy with where the grab-and-go window was going to be, which was basically the front door. And we asked to have it in the back side. So I guess those renderings will be done when your staff time allows.
correct.
I just wanted to ask, on this site plan, could you point out where our current barbecues are? Is that something that's doable for you on this site plan right here, the conceptual site plan? Just so that we can kind of figure out or see where the current building is and where the barbecues currently are.
I believe, here's the 9th green.
Yeah.
And the two sand traps in the front. I believe that picnic area is generally in this spot here.
Okay, so yeah, okay, we are definitely retaining that, because I know that was part of one of the issues that when you were doing the site plan, right?
Correct. We
Yeah.
were asked to work around the benches and the barbecue layout.
Mm-hmm, yeah, okay, thank you.
All right. No other board questions? Cindy, do you want to start going over the cards?
Sure, and looking at these cards, there's questions that I can help answer, and there's others that you can. So we'll start with parking. Hopefully you can answer this one.
How much additional parking will be available? We are going to have to work with Lake County on the parking. We're trying to maximize what we can get. There are requirements by zoning ordinance of what we have to calculate, and because of the picnic area, they use one parking stall for every 18 inches of bench area. So we're paying a huge premium for that. In an initial meeting with the county last spring, I think it was, they were very open to looking at how we could recalculate the parking to help make this project work. So we're very encouraged by what the response was up at the county. But we would try and maximize the parking available, even to the extent of, had talked about incorporating some parking across Hartman facility, and they were up to talking about that also, but perhaps not a permanently paved lot, but something that's more of a, I call it temporary paving, but still an overflow area that they wouldn't hold to typical county improvement standards. What kind of longevity is built into the design? That's always a difficult question, because with budget comes longevity, comes design, comes elements. So we would expect and want to design to a 20, 25, 30, 50-year building, but really that needs to be weighed against the budget and what we can do and the board's decision on where the money goes. There are things that we can do. What's a good example is the wood siding decision. Wood siding, if you paint it and maintain it, it's a terrific material. It's very, you'd love to really want to go up and touch it. It's natural. Probably has less life expectancy than plaster. Plaster is something that's very durable, and you can paint it and you can patch it and you can maintain it. So those are the kinds of things that we'd want to look at, is the differential between initial cost and life cycle cost on those elements. One of the other big items would be your mechanical system. You can choose a mechanical system that fits within a very low budget, but in 5 years it may need to be replaced. Or you can go out and figure that you want to pick a system that'll last 20 years and have lower maintenance cost over time, but you're going to pay a premium for it up front. Could the 2 new tennis courts be oriented north-south as requested by the tennis community? We've done a number of studies, and it is possible. There's some things that happen with the parking lot, and those are things that we'll continue to look at as we move into the next phase of the project. But it is possible. There are some compromises that would need to be made with the rest of the parking lot. You're writing bigger. This is great.
I know.
Is the building designed to be energy efficient, solar, et cetera? As far as the elements we have now, yes. Orientation, overhangs are being considered. The major items of energy efficiency, such as, again, mechanical systems, the type of glass that goes in, the amount of insulation, those are to be done in future phases, but we are always cognizant of trying to keep energy efficiency and your facilities maintenance cost as low as we can. What would happen to the current barbecue area and tables? What we're trying to do is maintain those, at least the area, because of the grading situation. The current building and parking lot is really too low. We would need to do some things about raising the pad up and getting subsurface drainage to work in the parking lot area. It may suggest that the barbecue area be raised. We might be able to leave it as is. If we raise it, could we reuse the benches? Certainly. That's a thing we would look at. So again, that's something a little further down the road. What is the mechanism used to isolate sound from the bar area from intruding into the dining area? I thought Wayne was going to take care of that. Some of our original floor plans, we actually had the bar flipped over and was really openable to the dining area because we were looking at being able to expand seating in certain events. Since that time, we've taken this bar and really flipped it over. We've got a solid wall that we can insulate. We can do a number of acoustical treatments to isolate the noise between the two. There's one aperture here for bar service. And what we've done is tried to take the bar view out across the lake and out to this patio area. So we've kind of done a little bit of a separation, if you will, of the noisier bar activities and the dining and meeting room activities.
It's a tough one.
Concerned with tennis court at the Hartman Gate. It will be difficult to see around it, and people walking across the roadway could be placed somewhere. Oh, could it be placed somewhere else? Also, indoor, outdoor fireplace and drop off for handicap if I drive that myself. The tennis court.
Number 12, two new ones. 12 up there, across the road. No, up top right.
Oh, really preliminary stages. We were just asked to see if we could fit those. Whether it makes sense or not, that's going to have to be a continuing dialogue. And I know there was previously talks about locating the tennis court or courts elsewhere on association property, and I'm sure that'll come up again. The indoor-outdoor fireplace, I'm not sure I understand the question. The drop-off for handicap, is that relative to the parking? We would have a drop-off lane where you could park there, be assisted out or get out. Our handicap parking would be either in this configuration here or in this parking configuration, most likely here because it's closest to the door. What is the square footage of our current Hartman building? Cindy has just told me it's 8,000 square feet. And is solar power included in this project? We would definitely look to placing solar power, again, a budget issue, but it's great. Even Cal Green, which is the new California Green Building Code, requires that roof areas be dedicated to have at least 10% of the roof, either now or in the future, dedicated to solar power locations. But I think, again, with the amount of wide open roof we have, we've got a great opportunity to get those incorporated into the building.
You're running out of questions. Let's see. This is a cute one.
When will the building be ready and we can have a drink on the deck?
Escape.
Who is this? Terrific. I think preliminary discussions have been a building that's occupiable sometime in spring or summer 2016. And I'll buy that drink. Could the 2 new tennis courts be oriented north-south requested by the yeah, again, we need to look at that in the area and the impacts to parking. There's again, that balance between parking requirements and the amenities.
There are a few more questions that I can answer. These are more operational items that you would not be able to. I'll start with currently.
Cindy, you want to get closer to the mic, please? Thank you.
Perfect. Currently, the outdoor dining area is used for smoking. Is there any designated smoking area in the new design? That would be an operational issue that we would put into place, or a policy from the board once the building's up and running. But I just wanted to know we did get your question. There's another here that says, will the association members be given full access to the findings and recommendations from the food and beverage study? The answer is yes. Jim Freeman, as I said, just finished up the study. I don't see that there would be any issue putting it online. Okay, so we could attach it to our website, and so everyone can view it. It says, if so, when, and if not, why? Well, it's not, so we will do it. The question is when. Ballpark? Jim says. Saying that Tuesday, okay. Then there's another that says, when will the golf feasibility study mentioned by GM Spears at a recent board meeting be done? That was something that ended up on our agenda, and feasibility really isn't the correct term. The term would be viewing and looking at our golf operations, and Wayne Clark and myself will be working together to go over expenses, revenues, cost, and we will be working together in the next month or so to view that. We're in our budget season, so now's the time that we can look at our expenses, look at our revenues, and whatever changes that we can make. So that's an ongoing project. Why have kitchen servers cross the hall to get into the dining room? Can that be redesigned? That was one of the questions when we came to visit about the hallway and the access to both the dining room and the bar. There are some new drawings. Would that be the correct? So there's going to be some revisions made that's going to address that concern. However, it would not change the square footage, so don't concern yourself with it being additional cost. This is back to the voting questions, which Jennifer has just answered, and that would conclude the cards that I received. There's a couple here that's asking about solar panels, if I can speak, solar panels, but we've kind of answered that. Okay. So I think that's it on questions.
I'm sorry, Mike. Mike, you're out of order, please.
Okay, any other question is, why is the association tennis court, why an additional tennis court when the present courts are underutilized? Conserve cost. That's was a statement. We got that one. Is there one we didn't? Oh, have you addressed the existing storage cart barn? I see a chimney. Is there a fireplace plan for the new building?
The cart barn, through our budget discussions in the last 6 months, 4 months, was something that originally we had the cart barn underneath the building, and we were probably in $250,000 investment to do that. Great place to have your cart barn. Costs, and because there's some water table concerns with the site, probably not something feasible. We looked at remote locations for new cart barns across the creek, closer to the commercial center to the west, and a cart barn located further up the first fairway when we had the driving range rotated. All that has got us right back to circle one with the existing cart barn location and either the possibility of dressing that up to match the existing building a little bit if the money allows, or that would be something that we would deal with in the future. So the cart barn location as of today is not really changed. And the fireplace, yes, we do have a fireplace in the dining room. We are hoping to be able to get an indoor fireplace and an exterior fireplace in the dining area. And we have a fire pit located off the bar and the view up to through the first fairway in this area. So a lower bar, definitely ways to get a flame protected for safety reasons, so it wouldn't be a completely open flame. You've probably seen those in different publications or in real life.
Here's another. How soon can this project get started? I think it meant, what is the projected cost of this new revised design?
In the last budget iterations and the number we've been talking about, we are at about the $5 million mark, and we're trying to hold it to that. We've had a little bit longer path than we've thought. We've got to go and look at what they call escalation and when the construction period would start. When we started the project, we were all in those economic woes. Contracting community has picked up in their business, and there is going to be a higher inflation escalation that we need to factor into what we're doing. So that's kind of the number we've been asked to keep on our radar screen. And again, we will do things during the design process to bring up opportunities to save money and opportunities to spend money where it's appropriate, like the considerations of mechanical systems, where it's a cost to the association when you're running a building, or any building owner, and you want to minimize those as much as possible, but then recognize what the initial cost is to do that.
This one you may be able to answer.
Are there any significant differences between scheme 1 and 2 other than exterior materials? No, it was just exterior materials. Cindy and Susan came down on Wednesday?
Wednesday.
And we had generated these elevations. We started looking at maybe some plan changes. Terry left town. I have the bag. And we just didn't have enough time to come up with a good plan and an elevation that we felt we could present and be comfortable with, knowing that we've got some of the bugs worked out of it. So I'm hoping our next iteration is going to be a little massaging of the plan, possibly moving the restrooms a little closer, dealing with the kitchen and access to the dining areas, and then re-engaging our vertical or our elevation schemes to match up.
And just note, that's not adding additional square footage. It was just taking what this plan was. Access to the bathrooms was a big concern, and also for our food and beverage staff. So we didn't make it bigger or smaller. It was using these plans and just kind of reconstructing where a couple items were. Here's another.
What are costs for the 2 displayed options, building, grounds, work, permitting, and environmental? we are pretty dialed in with the building cost, the grounds works cost. There's still some, what do we do with the tennis courts? The cart path locations. There's still some wild cards that we don't have final costs on, or even rough order of magnitude. Permitting and environmental permits, we haven't looked into that yet. We've got some idea what use permit and design review costs are, but as far as building permits, those are generally based on either the square foot of the building and the use, or based on the valuation of the building. So until we get a good valuation, we don't like to go to the agencies and tell them we've got this, when we might end up with this, and then we might be paying more for a permit than we should.
Here's another, show us the money as the first comment. And then we go down and say, are we going to receive a strategic and comprehensive community plan? The answer is yes. We've got a business plan in the works. We also will have our food and beverage survey back. So hopefully that answers that question. I'm just going to go through them all. Mike, has your question been answered? Yes. Okay, because I didn't. Okay, you're welcome. Some of this writing I can't understand. Basically, what it's stating. How will you consider the? Can you read this? I know it's not your question, but can you read it, or is it just me?
The estimate of $75,000 for a vote on facilities seems a little excessive, since we now have the internet available.
Okay.
How will you? Oh, this was.
Yeah, no, but it was in
and
these
Jennifer
cards.
left.
It must have been a Jennifer one.
Yeah.
But there's another card here, and I don't know if the two got mixed up. They shouldn't have, because we had two different piles. But during the break, it's brought to my attention by a couple individuals concerned about how we are communicating with the membership. We use clear lines of communication. We post our board meetings, whether they be a workshop, whether it's an actual meeting. If it's a membership meeting, there's a mailing that would be done to your home. There's notices placed on the community mailbox areas. So I'm a little confused on how we're failing to post these notices, because I know that we go to great extents to do so. If you have contact information or a new email address, because we have got complaints that certain individuals are not receiving our clear lines of communications, please update your email address with us so we can be sure to include you. But hopefully that answers that question. In my opinion, we go to great extent to make sure that we're noticing our meetings. Okay? That's all we have on questions on this side. Has everyone's question been answered? Let me ask that.
All right.
Okay, good.
Thank you. Go back to the board questions. Any? Susan?
Yeah, the question that came up about what is the life of this, the expected life of this new building, I think the person may have been, or at least that's what I would be interested in, is structurally what would you envision this to last, 40 years, 50 years, as opposed to siding and mechanical components and things, because we understand that you can do cheap siding, you can do good siding, you can do cheap components, you can do good, but the bones of the building, would you expect the bones of the building to last 50 years or
Yeah, and
whatever?
actually when we went through this building, and this is 50 years old, the bones of this
Almost.
building are very good. It's the siding and the windows and where the water penetrations come in. There are code things with this building that don't meet current code. A building of this nature, whatever your structure is, you're really dependent on how you're protecting that and how you're maintaining it. So siding and maintaining the sealants, water penetration, and then keeping updating the paint every 5 or 10 years, those are important elements. So the structure of a building like this should last you 50 years as long as it's well maintained and protected.
Okay, and then I just wanted to address the survey versus the food and beverage feasibility study. The survey was one piece of that, and I have seen some of the results of that, and it doesn't appear to be in summary format. So my partner on the food and beverage feasibility study, and I might want to see that before it gets published, so that it's in some kind of, sensible format, and see if we can do some correlations for certain questions, because I didn't see that in the information I got. It was way too much detail, But the part of the feasibility study also is market research related to what the income level is here, what is the average for discretionary spending that folks spend on meals to go, or meals out, I should say. Where are people currently going out for dinner, so that we can project the market demand, which was not really what we were attempting to pick up in the survey. So that once we get all that information together, it will feed into a business plan that Tammy is working on with a consultant to come up with some expected amount of sales that we can have in that facility. Okay? And then somebody else asked about, are we going to have a comprehensive strategic plan for the community? Well, in the budget session the other night, that's one of the things that I asked for next year, that if we could get together to start to do a visioning program like that. So that kind of a strategic, 5-year plan will have to be done next year if the rest of the board agrees that we can, that we should focus on that and that we have money to put towards that.
Bob, do you have any more questions? No? Anybody down there? Good. Okay. Question I have is, what would be the next step if we were to go forward from here and take this to the next level?
Okay.
What would the process be there?
Well, I'm going to take a step backwards and tell you where we've been, what we were charged to do in the beginning. And that was to come up with a conceptual site plan, elevations, and a budget for the project. And with the help of everybody on the board and the community, I think we've come up with a lot more than what was expected, especially how the interior part of the project works.
Right.
So we've gotten through what, again, we call conceptual design. The next typical phases of a project would be schematic design, which would start making the plan changes that we've been talking about a little bit, go back and look at our elevations and recraft those until we're comfortable as a group that that's the direction we want to head from the aesthetic and the costing, and get some schematic, very preliminary structural and mechanical systems ideas on how we would structure the project, on how we would condition the project and look at the costs of those. The next phase is what we call design development, which is where you take those ideas and that costing and further the design into really more detailed estimates, more detailed design, at which point a budget would be redrawn, and we can do that in every 50%, or depending on what kind of progress milestones you want to look at for each of these phases. And then we would take that, once everybody's comfortable with design development and the budget, we would go in what we call construction drawings, which are really the blueprints that everybody's used to, and that's the dimensions and the specifications, everything that a contractor would need to build the building, and that the agencies would need to look at it for permitting and plan checking purposes. After that's all done, we would go into bidding negotiations with a contractor list and then construction. Our next steps would be to get under an agreement to get us for those following phases, including we've got to touch base with Lake County on the use permit modification that's required, because this is in a commercial zone, and I believe it's 10,000 square foot or size limitation. A commercial zone might be 7. We've exceeded that, so we would need to go in and get a modification to the use permit to allow the greater square footage. And then they have something called their site and design review, which they take a look at the site plan. Typically all the departments get involved and they look at it globally and say everything looks fine, or you know what, you need to think about this, or we've got this requirement, consider that. And I know we're going to have those kinds of discussions relative to the location of the creek, septic system, sewer system, those types of discussions, water, definitely water is a big issue now, and building and planning, and just making sure that everybody is moving in the right direction. And it's always great to engage those agencies early, makes them part of the conversation. We get a lot of things ironed out, all the bugs, most of the bugs shaken out during that process. That
Pretty much, yeah. Is that something that we probably should follow this up with here then?
correct, 'cause we're basically concluded with our services. And our next step would be, once you're generally okay with the elevations, we can get this off to our host of engineers and consultants. We would engage with a civil engineer to do our grading and our site utilities, structural engineer to do the engineering of the project for the structure. We've got mechanical, plumbing, and electrical engineers that we would engage. We may decide that acoustical engineer might be somebody we want to bring in, depending on how we want to dial the acoustics of the project in. Landscape architects, certainly, so we can get our edges coordinated with the golf course and the street frontage. Interior design, which is something that Williams & Patton does. A number of the projects that we've shown you have been our work. So that would be something we would propose on to you.
So I think we're getting to the point where we need to take this to the next level and get a little bit more specific on this so we can answer these questions a little more specific. Is that something that you could work with staff on and get together and come back to the board with a proposal on?
We'd love to, definitely.
Okay, as a consensus thing to turn this over to staff for the next level, does anybody on the board have any objections to that? So I think that that's the plan, and maybe we can pull all this together and come back with that plan by, I think it'd be a little bit late to get it in by the next board meeting, but maybe on September, our first meeting in September, maybe staff can come back to us with a proposal on that. Is that all right? Thank you. With that, I will call this meeting closed. Thank you all very much for your attention.